While we're still waiting for people to trickle in, I'm just going to start with some bios for our amazing guests. So with us today, we have Professors Leah Litman, Niko Bowie, Melissa Murray, and Chris Kang. Professor Niko Bowie is an assistant professor of law at Harvard Law School. He's a historian who teaches and writes about federal and state constitutional law and local government law. In addition to teaching and writing, Professor Bowie litigates with the Committee for Public Counsel Services, the Public Defender Agency of Massachusetts. He sits on the City of Cambridge's Planning Board, which applies and recommends changes to the city's zoning ordinance. He's on the board of the Lawyers Committee for Civil Rights and Economic Justice, which advocates on behalf of immigrants and people of color. Professor Melissa Murray is a leading expert in family law, constitutional law, and reproductive rights and justice. Murray's award-winning research focuses on the legal regulation of intimate life and encompasses such topics as the regulation of sex and sexuality, marriage and its alternatives, the marriage equality debate, the legal recognition of caregiving, and reproductive rights and justice. She's an author of Cases on Reproductive Rights and Justice, the first case book to cover the field of reproductive rights and justice stories. Professor Murray is also a co-host of the podcast Strict Scrutiny. Professor Leah Litman is an assistant professor of law at Michigan Law, where she teaches and writes on constitutional law, federal post-conviction review, and federal sentencing. Professor Litman maintains an active pro bono practice. She is part of the litigation team in a Garcia versus United States, which is one of the challenges to the rescission of the DACA program, for which the team was recognized as California Lawyers of the Year. In the Supreme Court, she's currently on the merits of briefs for Hernandez v. Mesa. Before that, she was on the merits brief in Whole Woman's Health v. Hellerstedt, and Professor Litman is also a co-host of the podcast Strict Scrutiny. Chris Kang is Chief Counsel of Demand Justice, a new advocacy organization empowering citizens to organize around our nation's courts and fighting for progressive change, because the rights described in our Constitution are only made through the power of citizen activism. He has been an ACS board member since 2016. Chris served in the Obama White House for nearly 7 years as deputy counsel and deputy assistant to the president, senior counsel to the president, and special assistant to the president for legislative affairs. He oversaw the selection, vetting, and confirmation of more than 220 of the president's judicial nominees, who set records for the most people of color, women, and openly gay and lesbian judges appointed by a president. So it's now 12:06 and we're seeing people still rolling in, but we have a pretty nice group here, so I think we're just going to dive in. So we're going to start by discussing Professor Litman's recent article titled "Lawyers' Democratic Dysfunction." Professor Litman, can you please give a brief overview of the central argument of your article, and can you give some examples from the article or otherwise of this type of problematic behavior?
Sure. So the article you mentioned was part of a symposium on Jack Balkin and Sandy Levinson's book, Democracy and Dysfunction, that described the first few years and lead up to the Trump presidency. And the debate between them focused on whether the democratic dysfunction that they observed was endemic to the Constitution or was instead part of the sub-constitutional norms that we have worked out as a society and government. And one of the norms that I added to their list of contributing factors was what I called lawyers' democratic dysfunction, namely the network of lawyers' unwillingness or inability to hold other lawyers accountable for the breakdown of important constitutional norms to our democracy. By hold accountable, I meant something as simple as not supporting someone for a promotion or a future government appointment. I was not advocating for, nor do I advocate for, things like criminal sanctions or challenging whether someone, should remain licensed to the bar. In the piece, I also argue that there are hard line drawing problems between the kinds of norms that the network of lawyers should be attempting to police and the kinds of norms that merely reflect, disagreement about legal conclusions or policies. So some of the norms that I think are integral to a democracy are things like voting rights. You know, are you willing to say that the winner of an election should be able to assume power and that the loser should concede? Is that an important constitutional norm? Are you committed to the idea that, you know, people should be allowed to vote and that voting should be accessible? The other norm that I focused on in the piece was, you know, for me, a turning point that kind of crossed the line from mere policy agreement to something much more significant, and that was the administration's forcible separation of families at the border. Obviously, more recent reporting has come out about that policy since I wrote the piece, including, you know, former Deputy Attorney General Rod Rosenstein saying it doesn't matter how young a child is, you still need to prosecute their parents and separate the parent from the child. And so it's a combination of, you know, norms that I think are essential to a functioning democracy, as well as the kind of bare minimum substantive norms that I think we should, as a profession, be holding ourselves to. And, you know, I suggested that there is just some discomfort among elite lawyers with holding one another to account for breaching these norms. Again, you know, holding accountable merely means, you know, not going to bat for someone who has violated those norms or participated in their breakdown.
Thank you. And thank you for writing that article. You know, I think all of us here really felt that something like that needed to be said. And that's actually a really great segue to a question I was going to ask about Rod Rosenstein and former Attorney General Jeff Sessions. As you just stated, both of them, you know, recent news has come out that both of them were actively involved in the family separation policy. And first of all, that it occurred at all is obviously quite horrifying. But Rod Rosenstein is actually now a partner at the law firm King and Spalding. I'd love for any of you to weigh in on this. But first, from Professor Litman, what does it mean to employ someone who condoned and encouraged a policy as cruel and inhumane as family separation, and what kind of remedies can we see for such behavior?
You know, I think it is a signal that there just aren't professional consequences or particularly significant professional consequences for, again, you know, participating in family separation, advocating its enforcement, and furthering it as a policy if you're welcome back as a partner in a major reputable law firm and are paid at the salary that major law firm partners are. So, you know, again, I'm not suggesting that Rod Rosenstein should be thrown in jail. I don't think that, you know, prosecuting government officials is where our democracy should be moving toward. But I do think that it is and should be part of a healthy constitutional democracy if civic society and the legal profession were willing to say, look, there are just certain things that we think you should have to endure some kind of professional consequence for. And that professional consequence can be you don't get to be a partner at a big fancy law firm.
Great. And does anyone else want to weigh in on this?
I'll weigh in sort of a little bit generally. So first of all, thank you for holding the panel. Thanks for inviting all of us. Looking forward to continue talking about this because I feel like until I read Leah's article, it felt like something that was just under the surface in a lot of conversations that I've had in private without really having a necessary public conversation about how to hold people in account. And just one thing I'll add here is I think there is a very important norm about lawyers and the representation of clients. And one of the really important ethical norms is that a lawyer is not their client. And when you go to law school and you take legal profession or ethics, you learn again and again that what a client has done is different from who a lawyer is or how a lawyer should be held accountable. And so this is particularly important for public defenders. It's also important for any lawyer who represents an unpopular client. But that important ethical norm, which I agree with, is often used to justify all sorts of unethical behavior, including the separate and independent question of who does a lawyer choose to represent and what type of clients does a lawyer choose to take. And I think, especially in law school, but beyond, there's a conflation of the two norms. There's this idea that it's irresponsible or unethical to tell a lawyer the fact that you chose to go into this profession and represent this sort of client, or the fact that you put yourself in this position. So in Rod Rosenstein's case, the fact that he was in a Trump administration, he had a client. The client was theoretically the American people, but more directly, perhaps the Attorney General or the Trump administration. And theoretically, he could have been just carrying out his client's wishes. But he also made a choice as to accepting the position, staying in the position, not choosing to resign, and all of the other choices that he made that put him in the position to separate families from their children. And all of those choices are totally independent from the ethical norm of ensuring that everyone has meaningful representation. And so too often, I think I've seen people defend what looks like just really unethical practices by individuals in terms of who they go, what types of occupations they choose to have or who they choose to represent, on the ground that you cannot police or sanction in the way that Professor Litman is describing someone for their client's behavior. But I think separating a lawyer's representation from their client of who chooses to become a public defender versus who chooses to become a corporate partner or representing known clients who may do really just unethical behavior, I think that is an independent question that can be interrogated and should be in terms of evaluating professional consequences.
I wanted just to sort of piggyback on something that Niko said, and I would just note that to the extent that professional sanctions, and I don't mean disbarment or anything like that, but simply withholding of professional opportunities or whatnot, those kinds of consequences, I think, have been levied, but they've been levied unevenly. So I'm thinking back to during the Obama administration, a number of judicial nominees who were scuttled because of their role advocating on behalf of certain positions or representing certain people. It is, I think, very similar to the circumstances that we see now. If we were going to make a stand and say that someone in the Trump administration is not the sum total of the administration for whom he or she works, it also should be applied in the other direction. And I think all too often it hasn't been. And those who advance progressive causes or who defend individuals, public defenders or whatnot, those are the ones who often pay the price, the professional price of their advocacy. I mean, I think I'm the oldest person on this call, but I remember in 1994 when Bill Clinton advanced the nomination of Lani Guinier to be the Assistant Attorney General for Civil Rights, and her nomination was scuttled because of work that she had done as a law professor. And so when you think about who gets these sort of sanctions and to whom against whom they're levied, it is a really uneven picture, and I think it tilts in one direction.
So I'm obviously well aware of that precedent, but I just to piggyback on you as well, I think that's absolutely true, and I hope that we transition to talking about nominations, because I think there is a separate question that ties into toxic elitism in terms of who are the people that both Democratic administrations and Republican administrations feel comfortable nominating and going to bat for. And so looking at statistics, I'm sure that Chris can talk about this in detail, but looking at statistics of the Obama administration, for example, the vast majority of judges that President Obama nominated had backgrounds in working for corporate law firms, or the second most number were former prosecutors. Vast majority. Only 4 of his nominations as of midway through his administration were former public defenders. And currently, there is no judge on the Federal Court of Appeals who spent the majority of their career working for a civil rights organization. There are only like 3 who have any background as public defenders. And that's shocking. And the reason why I think this is in part because the nomination of a public defender or people who have taken controversial positions are really easy to bat down when they're not defended in the nomination process. All it takes is one client who has done something bad for Republicans or anyone else to seize on the nomination and try to tear it down. And so I think part of the solution is both defending the work that public defenders and civil rights lawyers and every other occupation in law does, and explain why that's so important for nominations and all sorts of professional consequences to get far more public defenders on the bench, but also to make it more controversial for someone to have had what's currently a non-controversial past. So for the people who have gone into working as corporate attorneys for their entire career and have that be the exclusive type of person who becomes a judge or someone in the federal bureaucracy, I think that should be controversial. And if there is, a Biden administration and they start nominating judges and it turns out that everyone who's being nominated has the same professional background, I think that deserves consequences, that deserves pushback, and it needs to be controversial.
So I'll pick up on that in President Obama and his staff's limited defense. The rules were very different, right? For the first 6 years of the administration, you had to get Republican support, and you had to have Republican support. Republicans had a veto over nominees in their home states. And so I think that the rules now are very different, and we should expect more. Although I will certainly concede we could have and should have done better in the Obama administration on measures such as professional diversity. I think that we have a couple different things that we're thinking about here. One is whether or not there's professional sanctions, as there were, in terms of what professional opportunities there are. I'm not surprised that a corporate law firm would hire Rod Rosenstein or other people. I think the other question is this idea of promotion, and like, who are we promoting and how are we using our privilege, sort of whatever the privilege is, however we come to it in, I don't know if I would call myself a legal elite, but perhaps by the fact that I've done some stuff, maybe I would. What are we going to do? What are we as lawyers going to do in terms of the privilege we have of our own legal elite status? And how are we going to promote people who are making very different legal choices? And I think part of it is this culture, sort of, it's a broad culture that the amount of money you make confers the status that you have and sort of your excellence, so that people who are in corporate law firms making a lot of money and having these the circles that they're in somehow are better lawyers than those who are in civil rights or public defense or things that I think the legal profession does not value enough from a monetary or status perspective. And so we have to sort of normalize that a little bit. But also just the idea that, like when Sheldon Whitehouse went on his presentation during the hearings on Tuesday and sort of walked through how Republicans have sought to overturn the Abood precedent to undermine public sector unions. We have corporate lawyers like Neil Katyal, who sort of is often touted as a progressive lawyer, who is on the side of undermining unions in 2 of those 4 cases that sort of have led to this precedent. Like this idea that we have that just because you're progressive in some things, that your corporate work is okay, I think is very problematic. I think that one of the reasons we're having this conversation this week is because there's now a genre of articles of what progressive person is going to come out and say, as a liberal, I think that Justice Gorsuch or Kavanaugh or Barrett is a good justice. And it's because of this culture here that we have, that it's sort of more important to be part of that club than to stand up for the values and principles that are at stake, that I think is really troubling, and also has to be part of how we think about what the elitism is and what the kind of culture is that it breeds.
So can I ask a question about this, Chris? I am totally on board with the whole idea that we should be bringing in people who are not typically part of those networks or hierarchies. But I worry that in making sort of a blanket prohibition or caveat that anyone who is in a law firm is somehow suspect, we are actually excluding a number of people who go to big law, not because they want to stick it to unions or they want to represent Walmart, but because law school costs $300,000 or they're supporting not only their immediate family, but also extended family. So drawing such sort of bright line categorical rules about the kind of professional profile that we want to see promoted and advanced, whether it's in judicial nominations or in other respects, do we inadvertently limit the kind of diversity we'd like to see in those positions by making such broad categories?
Look, I think that, as Melissa's sort of referring to, people may know Demand Justice has called for the next president, perhaps President Biden, to not appoint any corporate law partners to the bench, and sort of to have a moratorium based on the imbalance of the way that corporate law partners are represented among the judiciary. I think that, I think it's, for me, it's a closed universe of like even Donald Trump in this term is only going to get 200 and change judicial nominees. And I think that we can still strive and hit all of the different metrics of diversity and not have any corporate lawyers. That said, I think we need to at least flip the default. I think part of the challenge has been that the default is that prosecutors and corporate lawyers are the go-to source of judges. That's the sort of well-trod path, and we need to change the assumptions. And so I think that we should at least start with the principle that we can find a civil rights lawyer who is diverse, or a public defender who is also a person of color, or who is LGBTQ, or who is a woman, and sort of let's see if we exhaust that pool first. And if we exhaust that, still can't find somebody who meets every level of criteria of excellence that we'd hope for, then sure, maybe we can look to a corporate law partner. But I do think that the idea that that everybody goes to the people they know, and again, as we look at the ways that judges are picked, that they're often picked by senators who look to legal advisors who are themselves corporate lawyers or prosecutors, and sort of that is their network. I think the challenge is sort of how do you overcome that? And so I know that having a bright line may not be the right approach for a lot of people, but from our point of view, we at least need to change the way we think about this, and the most dramatic way is to flip the assumption of where we start to look and then work backward from there.
So I'd love to jump in here. We've talked a lot about things that we should be considering when we nominate people to the bench. And just for you all, what are factors that you would consider when you assess someone's nomination? Beyond these notions of brilliance, are we considering profession? Are we considering decisions? What makes a good nominee?
I would consider whether we went to a few happy hours together as a clerk and they smiled at me. No, I'm just kidding. That's a joke. Sorry, maybe a bad one. I think that some of the criteria that we have been suggesting, I think professional diversity is really important. And that includes not just the kinds of jobs that someone has had, but the kinds of representation that someone has done. It might be that there are some lawyers who have been, at various firms who do a lot of civil rights work or who work on behalf of consumers. I think there has been an incredible dearth of lawyers who work on behalf of consumers appointed to the federal courts. And I think it would be wonderful to get more of them on the bench, as well as more public defenders. I also think that the diminishing rates of racial diversity and gender diversity and sexual orientation diversity in the last 4 years really need to be counteracted. So those are at least 2 of the criteria that I think are really important to be thinking about. And that's where I would kind of start.
Yeah, I support all of those criteria too. And I just want to expand the reason for looking at different criteria a little bit beyond it's nice to have a good federal judiciary. In part to think about like what message the federal judiciary sends to law students. So law students come into a place like HLS, and the vast majority say that they're interested in something other than being a corporate lawyer, that they're interested in being an environmental lawyer or a civil rights lawyer, or a public defender or whatever, on day one of 1L year. And then you spend 3 years in which you're constantly just reading judicial opinions, all of which are written typically by either elite state or federal judges. And then you learn what did they do in order to get their position such that we are learning the law from them. And it's exclusively either being a prosecutor or being a corporate partner. Then there's all of the reinforcement of law school is extremely expensive. Law schools typically make it very easy to interview at corporate firms. And the net result is that there is a huge moving sidewalk toward one type of profession when the entire diversity of like reasons people come to law school in the first place are neglected. And so I think it's just really important, not just for making the federal judiciary better, but for saying, look, if you want to be a federal judge, if you want your opinions to be read by law professors in the future, these are the professions that are important. You know, you should be a public defender. You should go be an environmental lawyer. You should represent consumers. You should do what you came to law school to do and not feel like the only way in which you're going to be professionally recognized is if you be silent for the next 20 years about what you actually think, so that when you're nominated, you don't have to defend something that you wrote or said in front of the Senate Judiciary Committee.
So I'll say I agree with all of that. Niko and I both clerked for Justice Sotomayor, and I always think about her own experience and what she brings to the bench, not in terms necessarily of how her experience informs her decision making, although it may well, but just what it means to have someone who grew up where English was not necessarily her first language, where her family struggled financially, where she had family members who were involved in the criminal justice system. Like, that's a lot of people in the United States. And she's likely one of the few members of the court who actually knows what those experiences are like. And so to me, that was incredibly powerful to be able to work as a young lawyer for someone whose experience was not unlike my own, but also to know that as she became a justice on the Supreme Court, that there would be other people looking and seeing her example and understanding that there might be a path in the law, maybe even to the Supreme Court for them as well, and that there was someone on the court for whom their experience would resonate in a particular way.
I just wanted to piggyback on something that Niko ended his remarks with, which is not wanting to blunt the incentives for people to take stands on issues they care about out of fear that doing so would hurt their confirmation to be a federal judge. I think over the last 4 years, we've seen Republicans willingly and enthusiastically nominate people who have taken very clear views on issues ranging from abortion to, birther conspiracy theories involving President Obama. Whereas with Democratic administrations, we've seen nominees jettisoned, because they vocally supported different theories to protect the right to an abortion. Pam Karlan, who's a renowned civil rights advocate and a professor at Stanford, says, I would basically rather have courage and not trim my sails than be a federal judge. And I think we need to change that incentive on the Democratic side and be willing to confirm people who are willing to say things like, white supremacy is a problem in the United States, or, a range of topics that just shouldn't be disqualifying to nominate someone to the federal courts.
Yeah, I definitely think that, much the same way that President Obama's success in diversifying the bench from a demographic perspective, I think opened a lot of doors, opened a lot of sort of pathways for people. It's sort of the number of courts that now have their first woman or first person of color as a judge sort of shows that that path is possible. And I know in talking to potential candidates who came later in the administration that they wouldn't have thrown their names into the ring or even been considered because they hadn't seen that possibility. They hadn't seen that focus before. That's what we have to do on judges, right? We have to show that, because I think that a lot of young lawyers they decide, well, if I become a civil rights lawyer or ACLU lawyer, public defender early in my career, that's sort of an off-ramp to ever being considered to be a judge. And sort of talking to a lot of those people now who are, 10, 15, 20 years into their career, like it's taking a huge way to change their way of thinking, like, oh, I left that behind a long time ago. Now I've got to think maybe I could be a judge. Maybe I should be a judge. Like, we have to change the way that we're promoting, who we're promoting and how we're promoting them, how we're actually getting them confirmed at the end of the day, and open up this entire path so that more people will see that they can choose these careers even earlier on. And sort of still become a judge to the extent that a lot of us view judges as being the pinnacle of a legal career. I think that having that pathway cut off for so many people has been incredibly problematic.
So I hate to bring us back to current events, but we have a few questions about, the current Supreme Court confirmation process, and would just like to ask more broadly if, we can start with Chris, just because you just left off, does anyone have thoughts on, the dynamics that we're talking about right now and seeing them play out with respect to Judge Barrett's nomination?
Well, I do think that there continues to be this idea of sort of elites supporting each other solely for the fact that they're mutually elite. I do think that it's a little bit tempered in this time because having this confirmation sort of while millions of votes are being cast seems to be more of a bright line for folks. But I also think one of the interesting things that we haven't talked about yet when it comes to this culture of legal elitism is the attention that Judge Barrett has gotten for the fact that she only went to Notre Dame and sort of not Harvard and Yale. And I think that that's part of this too. Like, I think that part of what we have to think about as we think about the next generation of judges, or the next set of judges even that President Biden could appoint, is like, how do we get beyond this construct of you have to have graduated from a top 10 or even top 30 law school in order to qualify or be considered excellent enough to be a judge? I think that one of the things, the Center for American Progress did a study around the demographic diversity and lack of racial diversity around our judges. And one of the statistics that was most striking to me was that only 5% of Black students and 8% of Hispanic students go to top 30 law schools. And so, like, if that's our cutoff, when we think about like legal elitism and sort of think about how we're looking at who is qualified to be a judge, we're cutting off so many people, and particularly people of color, if those are our standards. And I also think, like, when I think about the legal elitism, like, one of the things that still pisses me off about the Sotomayor confirmation was seeing these legal elites sort of challenge whether or not she had sort of the legal chops to be the Supreme Court justice, and sort of seeing people sort of denigrate her in that way that I think is unique as a woman of color. And I think that that's part of the conversation we have to think about, is sort of how is it that we talk about people's legal education and the qualifications that sort of qualify them for these jobs in that regard as well.
Yeah, one thing I'll add is that is coming up in these hearings, that comes up in every hearing really, is this idea that there is a brilliant judge and that brilliance is a qualification for being a good judge. First, because brilliance is a meaningless adjective or noun. Like, there are many people who are brilliant in all sorts of different ways, but to describe one person as brilliant because they can read a judicial opinion or they can copy and paste a brief, like, okay, that's one metric of brilliance that I guess might make you, competent. But beyond competence and beyond the ability to do the job, being a judge requires judgment. It requires the ability to evaluate a situation and come up with substantively just outcomes. And to do that requires more than simply graduating from a school in which you've done well on a standardized test and you have been able to do, perform well on timed exams at the end of the semester under a load of stress, which is like what law school functionally evaluates. And being able to decide in a tricky situation, what is the just outcome, and how can a person navigate competing values and interests in a way that seems fair. And having good judgment has just so little to do with graduating through this meritocracy. It's almost antithetical to it, because people who have good judgment require balancing all sorts of interests and values that many of the people who are nominated for federal judgeships have just never had to confront in their lives. And that's, going back to what Professor Murray said, like, it's so important that people who have had, financial difficulty in their life, people who have had family trouble, people who have had to navigate just very difficult circumstances in order to get where they are today, like, they have exercised judgment, and they've exercised the kind of judgment that I would like to see in, full bloom on the federal judiciary and beyond. And so to describe, like, I think that in his nomination hearing, Brett Kavanaugh said he worked off his tail at Yale to get into Yale. That's one type of hard work, I guess. in your career, but there are many others that require better judgment. And in order to evaluate that requires more than quizzing a nominee on like, can you name all 5 or 6 freedoms in the First Amendment? And requires like, what are the circumstances in which you've exercised judgment? What are the contexts in which you have made a difficult balance of interests and come up with an answer that you're not necessarily satisfied with and may want to reevaluate? When have you struggled? All of those things are, I think, important for evaluating both judgeships, but also any type of professional nomination or promotion. And that's something that law school in general is just really bad at. Law schools teach procedural fairness over and over and over, but they don't teach substantive justice. How do you evaluate? What is a good outcome? And perhaps that's a difficult answer for a judge who is trying to be neutral. But maybe that suggests that neutrality and the inability to recognize when there is a need for substantive justice is a disqualification.
I'd actually love to use that as a jumping off point for you, Professor Bowie, on the role that law schools play in promoting this culture of toxic elitism, and what can law students do to force them to be better?
I think one thing is stop reading so many judicial opinions. There's the entire apparatus of law school reinforces the centrality of federal judges in all of our lives. There is, judges teach us what the law is. Judges give law students their first jobs after graduating for those who clerk. The entire law school apparatus encourages clerkship because clerking is great. But it all reinforces that federal judges are, as Chris said, the pinnacle of a legal career. And I think that one really important amendment to the law school process, to the institution, is decentering the role of judges and recentering the role of everything else that contributes to how law works. The reason why the Trump administration stopped separating families from their kids was not simply because of an injunction. It was because people were in the streets complaining and protesting and saying, this is substantively unjust, this is unethical, you cannot separate families from kids. And that's law. That's law in action, that's law in the streets, it's demos prudence. And so to center, like, the main debate among lawyers is textualism versus purposivism, or is living constitutionalism versus originalism, is to center a way of viewing what the law is and should be that is inherently elitist, in a sense that only a few elect can participate. And I think what law school needs to do in general is decenter that very narrow regime and focus on all of the other ways that law is made and changed and used to bring about good outcomes, as opposed to simply ones that are consonant with the text.
I also think, there's something to be said for the fact that the people who teach at law schools should think about the kinds of behavior that they model for their students. In addition to the lawyers, democracy, democratic dysfunction piece that we started out this presentation with, Diva Shah and I, Diva is an attorney at Kecker and Van Ness in San Francisco, just published a piece about how the same internal network effects of lawyers have also made it really difficult for lawyers to meaningfully address sexual harassment in the profession, because elite lawyers just find it again, sufficiently uncomfortable to speak out against other elite lawyers who are accused of sexual harassment, or other elite lawyers who may have covered for instances of sexual harassment. And so it's not just a matter of, judicial nominations, progressive values, or democratic ideals. All of those things are really important. It is also a matter of treating, one another and the profession with basic values of dignity and personhood, and we shouldn't let these network effects and idea that someone is brilliant or well qualified insulate them from having to abide by basic norms of interpersonal behavior in the law.
By the same token, and this is, I hope will be responsive to the question that Raisa Kramer has raised in the Q&A, the law school's understanding of what constitutes brilliance should not necessarily be the de facto measure by which we judge potential or prospective jurists. Raisa brings up the point that in a letter written just before President Obama announced his nomination of Justice Sotomayor, a law professor from Harvard sent a letter to him saying that she was not as smart as she thought she was. And, again, these are, I think, questions like who is inside, who is outside, who's part of the network, who is not. And I think it goes without saying who often is outside of those networks, who isn't understood as brilliant as a student or as a professor or as a colleague, and reinforcing that in the way we talk about who we nominate, whether it's to the judiciary or to executive positions, I think it's just re-upping on a kind of hierarchy that law schools are especially good at replicating.
So for Professor Litman, and then again to open up to all, there's definitely something to be said for playing the inside game. We know that all of the panelists here aren't just trying to tear down, legal elitism, but they're also working to ensure that people on our side succeed within the existing structures of the legal profession. So trying to get the students that they connect with clerkships, the attorneys that we like on the bench, et cetera. And how does that play in? And how should we think about operating within the system as it exists, even while we're trying to tear it down?
It's a tough balance. And I think, on any issue or on any given day, like the balance will probably cut in different directions. So when I talk to students about clerkships, like sometimes I will ask them, I'm happy to write a letter for you, but if you're applying to certain judges, like maybe am I the best recommender? Perhaps not. And, I sometimes think about that when I, say the things I do, or I write the things I write, like I am sacrificing some opportunities, like not only for myself, but also for students who, I could otherwise like recommend or support for particular positions. But at the end of the day, like I can't just myopically do the things that will open up every conceivable opportunity, professional opportunity under the sun, and wait to hold my fire until some magical day when it's finally worth it. I think there are a lot of things happening now that I wouldn't feel right about just kind of letting go. And part of what we are trying to do is to change the norms that Chris, Melissa, and Niko have all identified. We have to be able to make it more acceptable for someone who has those career ambitions and for people to be considered brilliant if they are, willing to stake out positions that might make some people uncomfortable or unpopular.
So I think some of it also, it depends on like how we talk about this and sort of what our criticisms are, right? Like I know that some people have criticized Judge Barrett because she's only been a circuit court judge for 3 years. There are a lot of reasons to oppose her nomination. I don't think that's one of them, right? I think that we should probably have more Supreme Court justices who haven't served any time as a circuit court judge. And so I think that we have to pick and choose sort of what credentials we think are actually important and what we sort of seek to build up. And so, look, I think that if somebody has been a Supreme Court or circuit court judge and that's part of their resume, then they should promote that and sort of by working within the system and sort of using that as a credential. But I'm going to be even more focused on trying to help promote the people who don't have those, who don't have the sort of clerkship or top 30 law school or sort of traditional path, but still could be great judges. And I think that that's sort of how we seek to strike that balance of both changing the incentives and sort of not having these be necessary credentials, while also not necessarily excluding the people who have them and sort of have been able to achieve these markers along the way.
Zarka has asked the question of how would you suggest thinking about the idea that we are responsible for our professional choices with the personal pressures that one might face in life, financial instability, fraught immigration status being a few examples. And I think this also gets to a point that Melissa raised about, a blanket rule potentially affecting people of color and getting on the bench. And what both of those questions or both of those comments have in common is they raise the importance of being intentional about evaluating choices. And that there are many reasons why someone clerks. There are many reasons why someone works for a law firm. There are many reasons why people decide to enter a particular career. Some of those reasons are ones that I personally would find both ethical and reasonable, and if I were in this situation, I would do the same. Some of them reflect a lack of judgment, that I'm doing this because this is the easy thing to do, or I'm doing this because everyone else is doing it, or I'm doing this because I thought it was bad but didn't feel like saying anything about it. And I think being intentional about the choices and the reasons why people make choices is important, both in terms of figuring out our own careers and for students figuring out their own careers, as well as evaluating people for professional advancement. And so in terms of my own participation in something like the federal judiciary through recommendations and being a commenter on what they do, I think one reason why I choose to promote clerking is because as a former clerk, I learned a lot and got a lot of professional benefit out of it. I don't think that my students should be excluded from those benefits simply because I am also critical of what federal judges do and the hierarchy that centering the federal judiciary promotes. I think you can hold those two views at the same time, even if at their extremes they're contradictory. But it requires nuance, and nuance is another thing that I think is a qualification for being a good judge, as well as just a good human being and a good lawyer, is appreciating that you can be very critical of an institution that you participate in, but the reason why you participate in that institution matters a whole lot.
So just a quick note, unfortunately, we're gonna have to have a hard stop at 1. But I would like to bring in a question from the Q&A, which is, how do we actively eschew elitism while still establishing important standards of judicial fitness? We've seen a lot of Trump judicial nominees who are young and relatively inexperienced, which I view as problematic. But then I have to ask, am I being elitist, and where is the line?
So I think that that's a great question. And I think that as we look forward to a potential Biden administration, and we think about what are the norms that Republicans have torn down with respect to consideration of judicial nominations that should be reestablished, although again, I think once a norm is discarded by one side, it's not a norm anymore. But in any event, what are the rules that we're playing by right now and sort of where we go? I definitely think that Joe Biden should look for people who have sort of had outwardly progressive legal careers and points of view the way that Republicans have chosen people who have had very conservative positions and legal views. I definitely think that President Biden should pick younger judges, certainly younger than President Obama did. But I also think there's a line. I don't think that we need to fall into every single trope here that Republicans have done, so that a lawyer who's only 8 years out of law school and has never tried a case, I think Democrats can do better than that. And I think we should hold ourselves to some standards. And so I think part of this is figuring out what is the requirement for being a judge? And then it gets back to what is their actual legal experience? What is it we're trying to promote? What is it we're trying to stand for? And I think that part of what we just need to be very, again, intentional about is saying that you can come from a broad array of legal experience and still be very qualified to be a federal judge. I think as we think about one of the many biases that are in the system is I think about the American Bar Association, how they have their standing committee of 15 lawyers who sort of evaluate judges. Every single one of them, I think right now, is a partner at a corporate law firm. And when I was talking to people on the ABA committee, and they do a lot of work, it's all volunteer, and I really applaud them for that. That said, some of the people that we talk to would say, from my perspective, I'm thinking if I have a multi-million-dollar case that's going to trial next week, is this person going to be able to handle that trial? And I don't think that necessarily needs to be the standard. I think that sort of sets in this idea that civil experience is more important than criminal, and sort of how you view the law is it's very reflective of your own personal legal experience. And so I think we have to be intentional about broadening the scope of what kinds of legal experiences are necessary while still maintaining some kind of floor that I think would lend itself to legitimacy to the judiciary.
I'd also just like to address very quickly something I think that a lot of people on this call right now have a very personal stake in. As I'm sure many / all of you know, the bar exam has been taking place despite the pandemic, forcing students to either take the exam in person and risk contracting COVID-19, to take the exam at home and have to endure, the challenges of the software, whether it be technical or even just not being able to get up from your seat at all during the exam, which, as also I'm sure many people saw, one woman gave birth during and, went into labor during the bar exam. And if not, you have to, forego taking the bar exam until a later date, which could put your career at risk or at least, hold off on when you're being paid. There's been a lot of criticism over the bar exam, saying that it is a tool that keeps people of color, people with disabilities, and low-income people out of the profession. And I'd just like to hear from any or all of you on whether there's merit to this criticism, and if so, what do we do about it?
Well, I think there's certainly merit to the view that these are extraordinary times, and assuming that everyone can do things according to the ordinary course is an assumption that we ought not make in this particular moment. And so, given that we are now hosting Supreme Court arguments telephonically and we are holding classes remotely, maybe it is worthwhile to think about other kinds of accommodation for the bar exam, like whether it's diploma privilege or something else, but the idea of postponing exams indefinitely doesn't seem reasonable. The requirements or the sort of constraints that have been applied to taking the test at home also seem to be unreasonable. We haven't even talked about the constraints that are placed on those with young children in the home. I mean, you already saw like my particular judicial nominee coming in here at one point already. But can you imagine being a young parent and having to take the bar exam for 3 days and never have an interruption when you're doing it at home? So I think just, even if we were going to focus solely on this moment, expecting everyone to be able to do things as we've ordinarily done them just doesn't seem reasonable. And maybe that opens up room to have a broader conversation about whether or not this is the appropriate way to assess fitness to enter the profession more generally.
And I think some of the most ridiculous things that were happening this past summer and early fall were because bar organizations were not prepared for what was happening. Like, obviously the pandemic really just became part of a problem that generated, widespread shutdown orders in March. And I don't know that anyone understood at that time exactly how we would be responding to it and knew that it would persist throughout the summer. Whereas now bar organizations should be looking ahead to next year's bar exam and understand that there is a very strong possibility that we are still going to be under shutdown orders in July 2021, or at least not back in place. And so there's really no excuse for them not to be thinking now and taking steps now to make accommodations. Obviously, the online exam formats didn't work well. There were a ton of IT issues. And I think they should be thinking now about, well, what sort of credentialing requirements and processes can we offer short of the bar exam for this next round? Again, knowing that they can prepare a year in advance. So I think in a lot of ways now is the time to be starting making demands of bar organizations, because they can be doing the planning now and won't be any excuse of, well, we're caught flat-footed and we don't know what to do, given that they should have seen this coming a year out.
I also think the incompetence of the bar commission or the bar association over the past several months has, for me at least, highlighted how the bar exam, just as an institution, deserves to be interrogated and possibly discarded. When many people need a lawyer, they're often at their most vulnerable moments. They have just lost their place to live. They're at risk of losing their child. They are in jail. Really difficult circumstances. And it's really important that when they consult a lawyer, that lawyer is prepared and equipped to handle their circumstance. There should not be people practicing who are ill-equipped to do that. But that raises the question of, does the bar exam, does quizzing somebody on their ability to retain all of the elements of what constitutes a will in Massachusetts, is that what will determine and filter out the people who are able to speak compassionately with a client, to represent them zealously, to be able to research something new that they don't know yet and look at that research in front of them, as every practicing lawyer does, and say, this is the argument that I would raise. Those are all things that the bar exam does not test. And so in the same way that Chris just mentioned that, there are a lot of qualifications for judges that seem like they should be qualifications, like you should be a, practicing Court of Appeals judge before you're a Supreme Court justice. And it turns out that that qualification is just both new and potentially harmful to the extent that it excludes just so many great justices of the past. I think the same is true with the bar exam, that the ability to do well on this sort of test over a 3-day period has often just very little to do with what it means to be a good lawyer. And to the extent there is a divergence there, that needs to be remedied.
So unfortunately it's 12:59 and we have to wrap up. I have so many more questions, and I'm sure many do as well. But first, I'd just like to thank you all. This has been an unbelievable panel. I've learned an insane amount, and I'm really thankful that you could all join us. I also just want to give a quick PPP shout out. Would be remiss if I did not. Rod Rosenstein came up multiple times in this conversation. If you think it's unacceptable that Rod Rosenstein has not faced professional consequences for his embrace of the child separation policy, PPP would love to hear from you. Please email hello@peoplesparity.org. Yep, Beth just dropped it in the chat, and yeah, it was amazing having you all here. Thank you so much.